Good afternoon, everyone. We'd like to welcome you and thank you for joining our webinar, FLSA Lawsuits and How Posting Compliance Affects Your Liability. A quick note before we get started. Please feel free to submit questions at any time during the presentation using the chat feature on your screen. We will respond immediately to any technical concerns, and any other questions you have about the information being presented will be answered as soon as possible after the presentation. And without further ado, here is Ashley Kaplan, our in-house senior employment law attorney. Ashley has been practicing labor and employment law for more than 18 years. Here at G-Neal, Ashley handles our legal compliance and also oversees the teams responsible for researching all the posting laws and developing Postregard services to meet our customers' diverse needs. Ashley has agreed to follow up with a response to any posting compliance questions you submit during the presentation. And as a special offer to our attendees today, she will also be available to provide a complimentary consultation about your specific posting compliance needs. If you are interested, please indicate that in the question box and we will contact you to set it up. And now, here's our presenter, Ashley Kaplan.
Thank you, and welcome everyone. The goal of today's webinar is to share some important information about the Fair Labor Standards Act, or the FLSA, and how posting compliance can affect your liability in an FLSA dispute. This is a really important topic because FLSA lawsuits are increasing year over year and are now at an all-time high. And they've actually started to become an area of concern for businesses of all sizes in all industries across the United States. It used to be that these lawsuits were just concentrated in certain geographic regions, but now we're starting to see them pop up in every state. Also, enforcement by the Department of Labor is on the rise and a big part of the agency's regulatory agenda for the next 2 years. So now is the time to review your policies and your pay practices and make sure you understand the law and have everything in order for full compliance. So today we're going to talk about the most common FLSA mistakes that lead to lawsuits and how to avoid them. And we're going to take a look at posting compliance and how it can impact you in an FLSA lawsuit or Department of Labor action. Most people think the worst thing that can happen if you don't have up the right labor law posters is a government fine. But we're going to take a closer look at the real danger of noncompliance and how posting compliance can affect the outcome of your case if you're ever faced with a wage and hour dispute under the FLSA. We're also going to go over a solution by Postregard that will help you manage FLSA posting compliance and all of the posting requirements that apply to your business. So hopefully you can cross posters off your list of worries and focus on other essential areas of HR, compliance, and managing your workforce. And finally, at the end of the presentation, we're going to take a look at some of the upcoming posting changes that we're expecting in the coming months that you should be aware of, the pending changes that are coming around the corner. So first, let's back up and go over some FLSA basics as a foundation before we get into the common mistakes. The FLSA, which is also known as the Wage and Hour Law, is one of the oldest employment-related laws on the books. But even though it's been around the longest, it's probably the most misunderstood of all federal employment laws. And I know from my experience working with all types of clients that this law can be really confusing. Employers and employees typically don't understand what it requires or how it works. Even lawyers and law firms make mistakes under this law. And actually law firms are starting to see lawsuits filed by their staff members, paralegals, and even receptionists for wage and hour violations. And often they didn't even know that they were occurring. So basically the FLSA is the federal law that dictates how you must pay your employees. We'll cover some of the specifics when we highlight the common mistakes, but here's a high-level overview of what the law covers. First, there's minimum wage. The FLSA requires you to pay non-exempt employees, which we're going to define in a moment, to pay non-exempt employees at least the current minimum wage for every hour of work. The federal minimum wage is currently $7.25 per hour, but the rate is higher in most states, and of course you have to pay the higher rate that applies to your employees. There's also a higher minimum wage now for employees of certain federal contractors. So you need to make sure you're aware of what rates apply to your employees. Next, there's overtime. The FLSA requires you to pay non-exempt employees at the rate of time and 1/2 their regular rate of pay if they work more than 40 hours in a work week. The law also covers child labor, including the types of activities minors can and cannot perform, and restriction on their hours of work. Then there are the timekeeping and record-keeping provisions, what records you have to keep for each employee and for how long. And the law also covers equal pay. It includes equal pay provisions for men and women. Now let's take a look at what the law does not require. And this is where there's a lot of confusion, and you get a lot of employees thinking they have certain rights that they don't. Under federal law, you are not required to provide meal breaks or rest periods. You're not required to pay a premium rate for holidays or weekend work. You're not required to provide any paid time off for vacations, holidays, or sick pay. You're not required to give any pay raises, and you're not required to get an employee's consent to work overtime. Now keep in mind that most employers choose to offer things like sick pay or pay raises just as a matter of keeping positive employee relations and attracting the best candidates to work for you, but it is not legally required under federal law. Also, keep in mind that there are state laws that might require some of these things, and that's the case in a lot of states. It's really important to know your state and local laws when it comes to wage and hour compliance. States are permitted to enact their own laws and regulations to provide even greater protection for their workers than are provided under federal law. So most states have higher minimum wage rates than afforded by federal law, and some states have specific laws about meal breaks and rest breaks, rules around sick pay, and other paid time off requirements. Of course, if you have any contracts in place, like executive agreements or union contracts, you also have to follow those provisions, even though not required by federal law. Also be aware that cities and counties can have their own laws that are even more generous to employees than provided by state or federal law. So make sure you're familiar with your local laws as well. And just as a general rule, whenever any of these laws conflict, you're required to follow the law that is most beneficial to the employee. So if your employees fall under 2 different minimum wage rates, for example, you're required to pay the higher rate. Now let's take a look at how the FLSA is enforced. There are actually 2 ways. The first is through the Department of Labor. And this typically occurs after an employee or a former employee makes a complaint to the agency. It can be anonymous, and it can trigger a full investigation of your pay practices. In fact, most of the time, the investigators uncover violations that the employee wasn't even complaining about. You know, they just have to make the complaint, it triggers the investigation, and then all of the other violations tend to rise to the surface. And if there are violations, the Department of Labor can collect penalties and other money to compensate all of your employees and former employees that were affected by the violation. Next, there are private lawsuits. And this is where an employee or even a group of employees retain a lawyer and sue you in a civil court action. This can involve months of discovery where you have to exchange evidence, you have witness testimony, documents, and it can even lead to a trial. In these private lawsuits, the damages also include attorney's fees. So these can be really costly, especially when you take into account the fees you have to pay your own attorney to defend the case and the fees you could potentially owe to the plaintiffs for their attorney's fees if you were found to have committed any violations. Okay, who can be sued under the FLSA? I've included this slide because unlike most employment laws, this is a law where employees can sue individuals within a corporation. Under most other employment laws, only the corporation can be held liable for statutory violations. But under the FLSA, individual business owners and decision makers can be held personally liable for violating the law. Courts have even held this to include supervisors, managers, and even HR personnel. So, of course, the employer or the corporation is also on the hook for violations, but a lot of these private lawsuits also name the individual decision makers as well. As I mentioned earlier, FLSA enforcement is on the rise. The latest reports on litigation trends up through the end of 2014 have been released, and they show that lawsuits alleging violations of the Fair Labor Standards Act are at an all-time high. In fact, wage and hour litigation filed under the FLSA produced more rulings in the past 2 years than any other type of workplace class action. And that's big. That includes employment discrimination cases and government enforcement litigation. So wage and hour litigation now represents the prime litigation risk in the workplace. The regions where we've seen the biggest growth with these types of cases are in California, Florida, Massachusetts, New Jersey, New York, and Pennsylvania. And just to give you an idea of the magnitude of these kinds of lawsuits, the enforcement actions brought by the Department of Labor have resulted in about $250 million per year being recovered as a result of employer violations. And for private lawsuits, the monetary value paid out just for the top 10 lawsuits in 2014 totaled over $215 million. And unfortunately, this trend is expected to continue. This is because of the momentum with the plaintiff's bar and also some changes within the Department of Labor's leadership where there are new and stronger initiatives in place to enforce these kinds of cases against employers. Actually, the Wage and Hour Division requested a 22% budget increase that would allow it to add 300 new full-time positions to help support its enforcement efforts under the FLSA. Also, with the new administrator for the Department of Labor's Wage and Hour Division, the agency has announced that it will focus on several priority industries. And the industries that are being targeted include eating establishments, hotels and motels, residential construction, janitorial services, moving companies, agriculture, landscaping services, healthcare and home healthcare services, grocery stores, and retail trade. This slide shows the list of the top 10 most expensive wage and hour settlements of 2014. These are the private lawsuits. And as you can see from this list, even some of the largest and most sophisticated companies get in trouble with this law. And as you're going to see as we review the most common mistakes, FLSA compliance is not common sense. In fact, this law often defies logic. And just when you think you're being generous and helping an employee out, you may really be violating the law. So now let's jump into the most common mistakes and how to avoid them. The first and by far the most complicated aspect of the FLSA and the area with the most common violations has to do with misclassification, whether an employee is classified as exempt or non-exempt. This classification means everything because it determines how you pay your employees and whether an employee is eligible for overtime pay. If an employee is exempt, that means the employee is not entitled to certain protections of the FLSA, such as minimum wage and overtime. So exempt employees can be paid on a salary basis instead of keeping track of their hours for purposes of minimum wage and overtime. But not every employee qualifies for this exemption, and this is where all the mistakes are made. There are very strict tests and legal criteria that must be established for someone to be considered exempt. And as you're going to see when we talk about these legal tests, it's all about the employee's actual job, duties, and responsibilities, not their title or how much they get paid. There are lots of highly paid individuals out there who do not qualify for exempt status. And those employees, no matter how large their income is, they need to have time cards and get paid overtime if they work over 40 hours in a work week. For all your employees who do not meet the legal criteria for an exemption, they are considered non-exempt, and they're entitled to the fullest protection of the law when it comes to minimum wage and overtime. So this means they must keep accurate time records, and they must get paid overtime for working more than 40 hours in a work week. I think the most common error made by employers resulting in FLSA violations is equating the term salaried with the term exempt. So while a lot of salaried employees do meet the law's criteria for exempt status, just merely being paid a salary does not render an employee exempt from minimum wage or overtime. A salary basis of pay is only one factor in the determination of whether an employee qualifies for an exemption. The remaining criteria relate to the employee's duties, responsibilities, and qualifications. So first of all, what is a salary basis of pay? This is required for almost every exemption, and it means the employee consistently receives the same amount of pay every week, no matter how many hours they work or how much work they've produced. And that's true even if you're closed for some of the weeks, you shut down early, if the employee leaves early every day, or even if the employee fails to get his work done. The basic rule is that a salaried employee must be paid his or her full salary for any week in which he or she performs any work, regardless of the number of days or hours he actually works. So this means you cannot deduct from the salary for production issues, absences, or lack of work. There are some very limited exceptions that we're going to touch on in a moment, but as a general rule, the salary basis of pay means the salary is always consistent without deductions. So remember that exemptions are not created by salary alone, and they are not based on any one factor like job title, level of education, license, or professional degree, pay level, or even an employee's request to be treated as exempt. The only way to establish an exemption is to meet the law's specific job duties tests and the related criteria set out in the regulations. So now we're going to go over the job duties tests for the most common exemptions. We could easily spend a full day just going through all the exemptions and their legal tests, but we're going to just touch on the most common ones to keep on track with the agenda for today's presentation. If we get to a specific exemption that you'd like to know more about, please indicate that in the question box or send us an email, and we'll be sure to follow up with you with more information on that exemption. So by far the largest category of exemptions that are relevant to most businesses is collectively referred to as the white-collar exemptions. And the white-collar exemptions include executives, administrative employees, and professionals. So let's start by taking a look at the executive exemption. This is the one that commonly applies to managers and supervisors. But be careful, not all managers or supervisors will qualify when you look at the specific requirements for this test. And be especially careful with assistant managers and line supervisors. This is an area where the Department of Labor has been cracking down and finding that most are not exempt and should be receiving overtime pay. So to qualify for this exemption, all of the following criteria must be met. First, the employee must be paid on a salary basis in an amount of at least $455 per week. And remember, for each of these tests, when we say salary basis, this means the same amount each week regardless of quantity or quality of work. Second, the employee's primary duty must be management of the employer's enterprise or customarily recognized department or subdivision thereof. And this is straight from the regulations. I'm going to try to explain some of the terms that are tricky or that are really important. In this part of the test, the term primary duty means the principal, main, major, or most important duty that the employer performs. So a duty that comprises 50% or more of the employee's job is generally considered the primary duty. So in this case, for the executive exemption, the employee's primary duties must involve management activities. Third, the employee must customarily and regularly direct the work of two or more other employees. And customarily and regularly appears in a lot of these exemption tests. And it is defined, and this is a quote from the regulations, as work normally and recurrently performed every work week. It does not include isolated or one-time tasks. So also for this exemption, two or more other employees means two full-time employees or their equivalent. So that could be one full-time employee and two half-time employees, for example. But an employee who just assists the manager and supervises employees, even if it's a lot of employees, only in the manager's absence, just to sort of fill in as backup for the manager, does not meet this requirement. It has to be a regular, primary duty, a regular job duty. That it has to be something that the employee is constantly responsible for in terms of supervising the work of at least two full-time employees. And finally, the fourth part of this test is the employee must have authority to hire or fire other employees, or his suggestions and recommendations as to hiring, firing, advancement, promotion, or other change of employee status are given particular weight. The next exemption is probably the most misunderstood and the one that employers misuse the most, and it's the administrative exemption. To qualify for this exemption, all of the following criteria must be met. First, the employee has to be paid on a salary basis or a fee basis in the amount of $4.55 per week. Next, and this part can be tricky, the employee's primary duty must be the performance of office or non-manual work directly related to the management or general business operations of the employer or the employer's customers. So to meet this requirement, this part of the test, an employee must perform work directly related to running or servicing of the business, which is different from than working on products or services that the business provides. So think more of the internal or functional areas of the business, things that the customer doesn't necessarily see, like the company's finance or accounting activities, or budgeting, auditing, insurance, quality control, purchasing and procurement, marketing and advertising, safety, health, human resources, IT or internet administration, legal compliance, and other activities like this that are sort of behind the scenes but critical to running a business. The third part of the test can also be tricky. The employee's primary duty must include the exercise of discretion and independent judgment with respect to matters of significance. This means the employee has to have authority to make independent decisions free from immediate direction or supervision. And the decisions can't be just a matter of following a specific set of directions or guidelines. The regulations are clear that this does not include clerical work or secretarial work or anything that's repetitive or routine based on established procedures or guidelines. It must actually involve independent decision-making on significant issues. These are some examples of positions that generally, but not automatically, they generally meet this requirement for the administrative exemption, and those are insurance claims adjusters, financial analysts, project or team leaders, executive assistants to a business owner. So again, it's not all secretarial or clerical employees, but an executive assistant to a business owner, HR managers, and purchasing agents. Those are examples provided in the regulations. The next white-collar exemption is the learned professional exemption. And to qualify for this one, all four of the following criteria must be established. The employee must receive at least $455 per week on a fee basis or a salary basis. Next, the employee's primary duty must be the performance of work requiring advanced knowledge. Work requiring advanced knowledge means work that is predominantly intellectual and requires the consistent exercise of discretion and judgment. It cannot be routine mental, manual, mechanical, or physical work, and it can't be attained at the high school level. So the third part of the test is really critical, and that is that the advanced knowledge has to be in a field of science or learning, and for purposes of this test, that means that generally includes professions in law, medicine, theology, accounting, engineering, architecture, teaching, and various types of sciences. And finally, the advanced knowledge has to be customarily acquired by a prolonged course of specialized intellectual instruction. And what that means is that it has to be an area where specialized academic training is a standard prerequisite for entrance into the profession. And the best evidence that an employee meets this requirement is the possession of the appropriate academic degree. So an advanced degree is typically required. These examples might help illustrate. These are from the regulations, and these are some examples of professions that are generally exempt under this test. And they are registered nurses, but not LPNs. Registered nurses are considered exempt, but LPNs are not. Dental hygienists and physician assistants, if they've completed 4 years of study in an accredited program, and the regulations give some more specifics about what an accredited program means for each of these. CPAs, but not bookkeepers or clerks. Chefs with a 4-year degree in culinary arts, but not other cooks. And athletic trainers, if they've completed 4 years of study in an accredited program. Again, there are more specific definitions of what is required for these programs. There are 2 more types of learned professionals that I'm just going to touch on briefly. First, there's the creative professional exemption. And to qualify for this one, the employee must receive at least $455 per week on a fee basis or salary basis. And the employee's primary duty must be the performance of work requiring invention, imagination, originality, or talent in a recognized field of artistic or creative endeavor, such as music, writing, acting, or the graphic arts. This requirement generally is met by actors and musicians. It's also met by artists and writers if the employee has a lot of creative license and is only given a general subject matter. Creative license is key here. The exemption does not apply to work that can be produced by a person with general creative abilities and training, such as a copyist or a photograph retoucher. Those positions would not be exempt under this one. And finally, there's the computer-related professional exemption. And to qualify for this one, the employee must receive at least $455 per week on a fee basis or salary basis, or at least $27.63 per hour. It's the only one like this with an alternative for an hourly rate. And the employee's primary duty must consist of a combination of any of the activities that are listed here. I'm not going to read them all, but the gist is that there's a certain level of expertise required to be considered exempt. So activities like such as computer repair, systems analysis, and programming may not qualify under this exemption. So this one can be really tricky, and you would probably want to work closely with one of your leaders in IT to make this determination for each job position within that department if you're relying on this exemption. So those are the most common exemptions. There are several others, but like I said, we're not going to cover all of them today. But I did want to at least provide a list in case any of these pertain to your business. Now some of these can be confusing on this list because they're considered partial exemptions, where, for example, an employee is exempt from the overtime provisions, but still covered by the minimum wage requirements. So in that case, they would still have to keep a time card to ensure compliance with the minimum wage requirements, but they wouldn't be eligible for overtime. So again, please let us know if you'd like more information on any of these exemptions, any of the ones that we've covered or any of the ones on this slide, and we'll follow up with you with more information. Now let's continue with the most common mistakes to avoid, and the second one is not paying for unauthorized overtime. This mistake is so common. I hear about it all the time from my clients. And the question I always get is, what if we have a strict policy in place prohibiting overtime? In some cases, it may even require written approval for overtime. And an employee violates that policy and works overtime without approval, without authorization. In other words, you didn't ask them to, but they either stayed late, they took work home, maybe they worked through their lunch break, whatever it was, but it was done without authorization. And this is where the law defies logic. Even though the employee violated your work rules, you still have to pay that employee overtime for the hours that he or she worked. The rule is that employers are obligated to pay non-exempt employees for all time the employee is performing work, whether it's authorized or unauthorized. Now just keep in mind, when we're talking about non-exempt employees, whenever we're talking about overtime requirements. So this doesn't apply to your employees that meet any of the exemption tests and are paid on a salary basis. So according to the Code of Federal Regulations, this is the standard, it is the duty of the management to exercise its control and see that the work is not performed if it doesn't want it to be performed. Management cannot sit back and accept the benefits without compensating for them. So in other words, it is your job to enforce your policies prohibiting unauthorized overtime. But if your policy is violated, and of course that means that your company has benefited from the work that's been done, you have to pay for it. So what can you do about this? Well, first of all, you want to make sure you have a policy in place, a very clear policy in place about unauthorized overtime, and that you've communicated it effectively. Make sure that your employees know about it and have signed off to acknowledge it. Then, if an employee works unauthorized overtime and violates your policy, the only thing you can do is administer the proper disciplinary action, whether it's a formal write-up or something more severe if it's a repeat offender, but you still have to pay the employee for the hours worked. And by the way, it doesn't matter if the employee volunteered to work off the clock. The FLSA is a law that employees can't waive their rights under. So if a non-exempt employee begs to be paid on a salary basis and forgo overtime, or insists on working off the clock for free, it is still an FLSA violation for you to allow it. Okay, moving on, another common mistake I see all the time is making automatic deductions for meal breaks. A lot of companies have automatically programmed their timekeeping systems to deduct a certain amount of time each day for lunch. So, for example, it appears on the time records that every employee punched out every day from exactly 12 to 12:30 for a 30-minute lunch break. Whenever a Department of Labor investigator sees this, it's a red flag because, well, first of all, it's highly unlikely to be an accurate reflection of each employee's actual work hours. In reality, in most cases, an employee starts or ends his lunch break at varying times. And the employee should be required to punch out, and back in to indicate exactly when he's not working. And if that employee doesn't take a long enough lunch break, that break time might be considered compensable time. And this is really important. To count as a legitimate break or non-compensable unpaid time, meal periods need to be at least 25 to 30 minutes of uninterrupted time where the employee is relieved of all work duties and can use the time as he or she sees fit. So this means if a non-exempt employee performs any work-related tasks during their break, even answering the phone, you may have to pay him for the entire break. So don't let your employees work during lunches or eat at their desks while working if they are punched out on break. And this goes for any break. And by the way, for short breaks that are 20 minutes or less, you shouldn't be requiring your employees to clock out at all. Short breaks are counted as working time under the FLSA, and you need to manage them according to your company policy, and as far as how many breaks you will allow and how long the breaks can be. But they are counted as working time if they're 20 minutes or less. So employees should not be punching out for that. Also, state and local laws might require a certain number of breaks per shift, or they might require that the breaks are of a certain duration. So make sure you are clear on what laws apply to you when you're putting your break policy into place. This is a hot issue on a state level, so it's very important that you're clear on your state laws. And also just a little tip, if your timekeeping system does automatically deduct for meal breaks, just make sure you have a system in place that allows your employees to report instances when they're unable to take their full meal break. So, where they can edit their time that day. So, if it always shows from 12 to 12:30, that there's a way that the employee can make edits or let you know, today I wasn't able to take my full break. I only took 15 minutes. And, of course, you can deal with that as a management issue. You also need to make sure your supervisors are responsible for reviewing and confirming the accuracy of these reports, and we're going to get into that in a little bit. The next common mistake also applies to your non-exempt workers. And this is another one where you think you're doing something nice, you think you're doing someone a favor, but it ends up being an FLSA violation. And this has to do with comp time. So a lot of times your employees will ask you for comp time, where they want to work extra hours one week and then take off that time another week. So essentially they want to carry over their hours from one week to another. The problem with this is that the FLSA looks at each work week independently. Each 7-day period stands alone. So if an employee works more than 40 hours in a given work week, you have to pay overtime, regardless of how many hours they worked the week before or the week after or any other week. Again, it doesn't matter if the employee asked for this arrangement. It is not permitted under the law. I've even had clients think that they thought this was a great idea to draw up their own agreements with employees who are requesting comp time to prove that the employee requested it and to waive their right to receive overtime pay. They're signing off on this. And this is horrible. It's something that is always a nightmare when it comes to me. And it just makes the case even worse because not only have you violated the law, now there's written evidence that you violated the law. There are a couple of exceptions when it comes to comp time for non-exempt employees, and I've noted them here on this slide. The exceptions apply to public sector or government employees and also to certain employees in the healthcare industry. Okay, the next mistake applies to your salaried exempt employees. We talked about one of the critical factors for being exempt, and that is being paid on a salary basis, an amount that is the same from week to week and doesn't fluctuate due to quantity or quality of work. So now take a look at this scenario where an employee gets docked for a disciplinary violation or his salary gets adjusted because he missed almost a whole day of work after running out of PTO. Believe it or not, both of these deductions would violate the FLSA. With your salaried exempt employees, the rules are very strict about making deductions. There are very limited exceptions when it's okay to reduce someone's salary. When it comes to personal or sick time and unpaid disciplinary suspensions, deductions are only permitted in full day increments. So this means you cannot deduct money if an employee performs any work on the day in question, even if it's just a half an hour or a couple of hours worked out of an 8-hour day. If an employee is exempt, then you generally can't make salary deductions for anything less than a full day. The reason is because the salary of an exempt employee is not supposed to be based on time, but rather it's based on the value that an employee brings to the company. So it's not legal to deduct an hour here or there, like if an exempt employee comes in late or if they leave to go to an appointment or an activity at their child's school. If you start making these partial day deductions or docking an hour here and there, the government assumes the employee is actually paid on a non-exempt hourly basis. And that can essentially destroy the employee's exempt status and make you liable for overtime pay, back taxes, and other penalties. That can be really costly. I've listed the salary deduction exceptions on this slide. As a general rule, you can deduct in full day increments from an exempt employee's paycheck for personal days, days missed during the first and last week of employment, before they start, or the days in the week after they've terminated employment, and also for sick days. But for sick days, this would only work if it was under an established sick leave policy. Like, for example, you allow for a certain number of PTO days, but the employee has either used them all up or it's a newer employee who isn't eligible yet for PTO. So you need to have some kind of sick leave policy in place in order to be able to deduct for days missed. There's also an exception that allows partial day deductions for intermittent leave under the Family and Medical Leave Act. But otherwise, you want to stay clear from partial day deductions. Okay, the final mistake we're going to cover involves mandatory record keeping and notification requirements. First, let's talk about time records. In this scenario, the company is allowing its employees to keep track of their own hours, then to only submit the totals every 2 weeks. The FLSA requires employers to keep certain records of employees' wages, hours of work, and other items as determined in the regulations and by the Department of Labor. There are lots of different ways that you can track your employees' hours, but the key is the records need to be complete, accessible, legible, and they need to be in a format that can be copied or reproduced if needed. But other than that, you can choose whatever system works best in your office, whether it's an electronic system or even if you're collecting handwritten timesheets. The key is that the records have to accurately reflect the dates and times of all work performed. And this record keeping requirement is the employer's job. It's the job of management. So it's your burden legally to prove the hours your employees work. It is not the employee's burden to keep track of this and prove their hours of work. So if you have time records that are incomplete or inaccurate and an employee later claims that he was underpaid, that claim will be nearly impossible for you to defend. So for this reason, you should make it the supervisor's duty to make sure that all time records are accurate and properly maintained for each work week. That is so important. So the best way to prove actual hours of work is to maintain records of all dates and times when employees start and end their work, including their meal breaks, punching out and punching back in, and to collect your time records on a weekly basis, as opposed to this scenario where the employer would just get the total for a week or two at a time, for 2 weeks at a time. You should also have each employee review their own times and sign off on the total hours at the end of each work week, indicating that they are accurate and complete. This is so important. A common mistake that supervisors make is accepting bad time records. I've conducted hundreds of audits of payroll records, and I can't believe how many of these time records make it through with cross-outs, times missing signatures. A lot of them are illegible. You can't even tell what the times are on the handwritten cards. If your supervisor discovers inaccurate or incomplete time records, they need to address them immediately. You should have the employee fix the mistakes and sign off on the corrections before you approve the time record for payroll. And remember, this doesn't mean adjusting an employee's hours if he actually worked them. I'm just talking about actual errors, mistakes, or things left blank. I've included a note here on this slide about rounding, because I get a lot of questions on this. It's okay to round your time entries, and you could do it to the nearest 5 minutes, tenth of an hour, or even quarter of an hour. You just need to make sure that your rounding practices are uniform and consistent, that you always do it the same way, up or down, and that over time it doesn't work to the employee's detriment. It needs to be fair and consistent. Another critical requirement that a lot of employers overlook are the FLSA notice requirements. This is the requirement that makes it mandatory for you to post a current notice that is issued by the Wage and Hour Division informing employees of their rights under the FLSA. The notice has to be posted in conspicuous locations throughout your business, that's the legal standard, to ensure that it is readily accessible to all employees. So in most cases, if you have a large facility, this means having multiple posting display sites for these mandatory posters. Also, I included in this last scenario a situation where the company employed telecommuters or off-site workers, because a lot of companies aren't aware that you have to get the same notices to your off-site or remote workers as you do with your on-site employees. This can be done in a variety of ways. Most companies use an electronic solution to reach out to their remote workers. But the point is, you need to make sure you get them the same information about their rights that you have to post on your walls. Now we're going to shift gears and talk a little about the FLSA posting requirement and how posting compliance can affect your liability in an FLSA dispute. And posting compliance, of course, goes beyond the federal FLSA posting. There are other federal postings you have to display, state posters, also some cities and counties have posting requirements, and then there are additional labor law posters required for federal contractors and employers in certain industries. And I'll give you a little more detail about that in a moment. We are going to jump into the legal impact of posting compliance and the dangers of noncompliance in an FLSA matter. But first, I want to cover some of the basics you need to know about posting compliance in general, just to put this into context. So today's posting compliance environment is more complex than ever. As most of you probably know, all businesses in the United States have to post both federal and state employee notices. And depending on what state you're in, this can add up to 21 individual postings that have to be displayed on your wall. This includes 6 mandatory postings on a federal level, including the FLSA posting, and up to 15 additional posters for state law compliance. This area of compliance is becoming more complex and difficult to manage over the years because more and more laws are being passed on a state level, giving employees protection in the workplace. And with each new law, there's a potential poster update or a new poster being issued. So these state posters cover a variety of topics, obviously the state minimum wage rates, fair employment, unemployment insurance, workers' comp, rules around smoking in the workplace, paid sick leave, child labor, and then some new areas we're seeing like human trafficking, expanded family care rights, and even electronic cigarettes in the workplace. Something that a lot of people aren't familiar with is that there's not a one-stop shop for free government posters. So while the various agencies do provide the posters, there's not a central place where you can get all the posters you need for compliance. So just for basic compliance, it takes quite a bit of know-how and resources to get everything you need. It's one thing if you just have one location to worry about, but for multi-site employers, there's actually, across the nation, there are more than 370 different posters that are required on a combined federal and state level, and these posters are issued by about 175 different agencies. And in any given state, just managing posting compliance in one state alone, an employer would have to go up to 9 different agencies to get their required federal and state posters. Now let's take a look at another layer adding to the complexity of posting compliance, and that is keeping up with the rapid rate of change when the government issues new or updated posters and the old ones have to be changed out immediately to maintain ongoing compliance. And as you all know, the agencies don't notify businesses when these posters change. It's the employer's burden to research and monitor and obtain the correct posters and to post them at the right time. The labor law posting requirements change frequently, and we've actually seen the rate of change increase to an all-time high over the past few years. Our legal team here at GNeil monitors and tracks all of the poster changes on a daily basis, and on average, we see about 150 state posting changes every year. And every time there's a posting change, our legal team reviews the underlying laws and the surrounding information about the poster to determine if it's a mandatory or a non-mandatory change. And at least half of the changes do require a mandatory update or an immediate replacement of the posters. So there's on average about 75 mandatory poster changes, updates, or new posters a year on a state level. In addition to analyzing the mandatory versus non-mandatory status of these changes, our legal team also reviews the posters and the underlying laws to determine if there are any foreign language posting requirements. A lot of these have mandatory foreign language posting requirements, size, font, or color requirements, and any special instructions that might apply, like to job applicants, federal contractors, and for certain industries. The state-specific wage and hour posters, the minimum wage posters, change the most frequently as states are starting to increase their minimum wage rates more frequently. In fact, we've already seen 21 states this year increase their minimum wage rates and update their mandatory minimum wage posters. So this is something to be aware of and to keep on top of. This chart goes state by state, and in the first column it shows how many posters, how many individual posting notices are required, including your basic federal and state postings for each state. And in the second column, it shows you how many different agencies are responsible for issuing those postings. This is just a good self-audit tool, a quick audit tool. So at a glance, you can see how many notices need to be posted on your walls for each of your locations, depending on what state you're in. We also have a much more robust audit tool with full images and revision dates. So if you'd like more information about the specific postings that are required for your locations, just indicate that in the question box and we'll be sure to follow up with you after the presentation. So as you can see from the chart, there are several states that have 15 or more mandatory posters. In fact, the smallest number of postings required in any state is 9. So there are a couple of states that only, I guess you could say only, have 9 postings that have to be displayed. And then the column to the right shows how many different agencies are responsible for issuing the posters in each state, which you can see in a lot of cases there can be 7, 8, or 9 different agencies to contact per state. Now we're going to talk about the risks of noncompliance and why it's so important to make sure you have all the current postings and your posting display sites are complete and up to date. In the statutes for the regular federal postings, the government is authorized to fine up to $17,000 per location for posting violations. And that could be for missing posters or outdated posters. And then on a state level, the fines are typically between $100 and $1,000 per violation. Fines for the city and county posters are typically in that same range as the state poster fines, but every posting law, city, state, and federal, has its own fines attached to it, so they're really all over the place. The government fines can really add up, especially if you have multiple posting locations. But the biggest danger with posting violations is related to employee lawsuits. And this is especially true when we're talking about the impact in an FLSA case. So there are a few different ways that posting compliance comes into play with employee lawsuits and FLSA disputes. The first and probably the most significant is when it comes to the statute of limitations. The statute of limitations can be an employer's best friend because it is the defense that allows you to have a claim stricken or dismissed because it was filed too late. So the statute of limitations, for example, for a federal discrimination claim is 300 days. For a Fair Labor Standards Act case, the statute of limitations is 2 years. So typically, if you get a claim from a former employee or an existing employee for a violation that occurred outside of that time period, you can move to have that claim dismissed and avoid all the legal fees and potential liability for the claims in the lawsuit. However, if you have a posting violation, courts have begun to publish more and more decisions saying that if an employee didn't have notice of their rights because the poster wasn't up, that the statute of limitations is extended or tolled, and you cannot use it as a defense. So we've seen several FLSA cases where normally an old claim could have been dismissed and avoided altogether, where the court allowed the plaintiff to pursue the claim, and it ended up in a 6- or 7-figure judgment just because the posters were not on the wall. The statute of limitations, it not only limits the time period when someone can sue you, but it also limits your exposure to damages, like how many years back you have to pay for a back pay award. This can be a big problem in any case where you're facing potential damages for back pay, where an employee's claim includes damages for lost wages going back in time. And that's common in lawsuits, any lawsuit alleging wrongful termination or unfair pay practices, whether it's brought under Title VII for discrimination, the FLSA for time and pay violations, the Equal Pay Act, the Americans with Disabilities Act, the FMLA, or just about any federal or state employment law that gives employees the right to sue in civil court. So let's take, for example, a case brought under the Fair Labor Standards Act for overtime pay. If you consider all of the employees affected by an overtime policy or a misclassification of a certain job position as salaried exempt, it can make all the difference in the world to cut off your back pay exposure to 2 years. Without the statute of limitations defense, you could be on the hook going back for years and years with liability for every employee in that particular job position who was misclassified, or every hourly employee that was affected or paid incorrectly under a faulty overtime policy or from a meal break violation. And that can really add up quickly. So obviously, posting compliance, it seems like something so simple. It is obviously worth the effort when you consider this level of risk, especially given the growing number of FLSA lawsuits and enforcement actions that we're seeing right now. There are lots of published court cases where this has occurred. We actually have a detailed white paper with examples. If any of you are interested in reading more about the actual cases, just indicate that in the question box or send us an email, and we'll be happy to email that to you after the presentation. So another way that posting compliance comes into play with employee lawsuits is as evidence of bad faith. And all of the different federal employment laws have different standards where the concept of good faith or bad faith affects the employer's potential liability. Like under Title VII for discrimination claims, you can be assessed punitive damages. Under the FMLA and the FLSA, you can be assessed double damages, or what are called liquidated damages. So depending on the law at issue, courts look at various factors to determine if a company acted in bad faith or good faith, like whether you had written policies in place, whether you trained your managers on compliance issues, what steps you took to prevent and respond to violations. And now we're seeing more and more cases where posting compliance is coming in as a common factor that the courts are looking at when making these assessments for good faith or bad faith liability. A finding of good faith is critical, especially in FLSA lawsuits. First of all, in an FLSA case, if you're found to have violated the FLSA, the plaintiffs are awarded their actual lost wages, and they automatically get liquidated damages that double the amount you owe. There is a defense, however, that can eliminate the double damages, when essentially that would cut your exposure in half. This defense requires a showing of good faith, and courts have started considering posting compliance as a factor when determining whether to apply this good faith defense. In fact, there's a recent case where the court specifically mentioned the employer's disregard for posting compliance as the reason for not reducing that double damage award. That's also covered in the white paper. So needless to say, it's important to make sure you're on the right side of the law when it comes to posting compliance. It simply is not worth the risk to cut corners, knowing the potential liability involved. Because of the complexity involved in keeping up with all the posters, the rate of change, and the severity of the penalties for noncompliance, GNEAL developed Postregard compliance protection as a solution to help employers stay on the right side of the law when it comes to posting compliance. I'm just going to cover a few basics about the program and some of the newest features and expanded compliance services that might apply to your business based on some recent legal developments and compliance trends. First of all, Postregard is a comprehensive labor law posting solution by GNEAL, and GNEAL is the industry leader in posting compliance for more than 25 years. And the way the service works is we start you out by sending all the mandatory federal and state labor law postings to each of your locations. Our posters are combined and printed in a condensed laminated format, and this is to save wall space, of course, but also to ensure durability and to protect the posters from being ripped or torn or covered up to ensure compliance. Once you get your initial postings, we take care of everything from there. Our in-house legal team monitors the posters daily for changes, and whenever there's a mandatory update, we automatically send you the new posters at no additional charge and that's no matter how many changes there are throughout the year. We've seen in some states in 1 year a state had 6 changes, so this can be difficult to keep on top of and costly if you're having to continue to replace your posters, pay for shipping, and buy new posters. We also provide a customized members-only web portal where Postregard members can track all of the changes and poster replacement activities for their specific locations. So at a glance, you can see all of your active locations, which ones have poster changes, and you can even track shipments to see exactly where the poster is in transit, when it arrived, and who signed for it. It also provides an audit tool for you and your location managers with full images of the posters, revision dates, and also posting instructions. Also, Postregard has a 100% guarantee against government posting fines. And this means that if you're a Postregard customer and you receive a government posting fine when you've properly displayed the most recent version of our posters, we take full responsibility for the fine. Something else worth mentioning, to help further protect you against damages and lawsuits, we also provide complete record keeping. We maintain up to 5 years of records, and we provide our customers with all the evidence and data that they need to respond to requests in litigation or government investigation. And this helps to prove that you are in compliance when it comes to all the posting laws applicable to your business. It shows the locations and the posters that you have at a given time. With all of our expanded services, Postregard offers the most comprehensive solution for today's unique workforce. In addition to our regular federal and state coverage, we also provide a special service for federal contractor postings, and these are really growing in number. There are currently 10 additional postings required for federal contractors, including a new one that was required as of January 2015, a mandatory update effective in March 2015, and at least 3 other mandatory changes that we're expecting over the next 6 to 9 months. By the way, this is another area that we could spend a lot of time on, and we have a great white paper on all of the federal contractor posting requirements that we can send you if you'd like more information on that. In terms of our expanded services, we also cover industry-specific labor law postings. And these apply in a variety of industries, but the ones with the most requirements are healthcare, the restaurant industry, and the public sector. So we've developed a 50-state solution for each of these industries. And depending on your state, this could mean another 20 or so postings per location that you have to display. We also offer posting solutions for your off-site or remote workers. We've developed an electronic solution that sends email notifications to your remote workers upon enrollment, and then again whenever there are mandatory updates. The notification prompts the employee to download and view the current posting images, and then it tracks the employee's acknowledgments with the time and the date so you have proof of compliance. We also have a binder format for small workspaces and non-traditional work sites without walls, such as mall kiosks, valet stations, or mobile service units, services on wheels, where there aren't walls to display the mandatory posters, and in a lot of cases employees don't have electronic access. They're not provided with access to email or the internet. We also have special solutions covering your applicant areas, since there are actually 4 federal posters that have to be displayed where all applicants can view them. We also have posting solutions covering all Canadian provinces, and another expanded service for cities and counties. A lot of cities and counties in the United States are now requiring labor law postings on top of the federal and state posters we've already talked about. We've actually just added another attorney to our staff to research and monitor these because there are so many new local requirements coming out. And finally, we also have foreign language posting solutions, including fully translated bilingual posters in Spanish and English. And by the way, something that's unique about Postregard, whenever a posting has to be displayed in a foreign language by all employers, we automatically include them on your English posters at no additional charge. And there are actually 22 states right now where certain posters have to be posted in Spanish by all employers, even if you don't have any Spanish-speaking employees. In those 22 states, I believe there are 46 postings that this applies to. So that's a big help to already have these covered in your regular English service. It's just something you don't have to worry about. Okay, as promised, we're going to wrap up the presentation with an overview of some of the mandatory poster changes we're monitoring right now based on laws that have already passed. This slide highlights pending changes based on federal and state laws that have already been enacted, laws that make the corresponding posters outdated and will require mandatory poster updates with the new information. Typically, a law is passed and the government updates the poster before the compliance deadline or the effective date of the law, but that is not always the case. Sometimes the law will go into effect and the government can take weeks or even months to catch up and get the new information onto the posters. So some of these effective dates have passed, but the posters have still not been released. And this is just a list of laws that have actually been passed with actual effective dates. There's a host of other bills that are pending in various stages of legislation that could also affect the posters. On a federal level, the posters may be affected by pending bills on issues like immigration reform. There are always proposed FMLA expansions. And there are hundreds of bills that are pending on a state and local level. But again, this slide just captures posters that are due to have mandatory updates based on laws that have already been enacted. If you have any questions about the specific changes you see here or how they will impact your business, please submit your question using that question box on your screen or send us an email, and we'll get back to you with more information on those. Well, that wraps it up. I hope you found this presentation to be helpful and informative, and hopefully you're walking away with some action items to help make sure you're in total compliance when it comes to these issues and the posting requirements that apply to your business. If you have any questions or would like additional information about Postregard or any of the compliance issues I've talked about today, please feel free to contact our compliance specialist, Sarah Santiago, at 954-514-2201. Or you can reach out to Sarah by email at ssantiago@postregard.com. Thanks again for attending today's presentation, and we hope you have a wonderful afternoon.